Hi, everyone, and thank you for joining today's national webinar. Today, we're joined by Bob Fuselier of Ambassador Property Management, discussing your affirmative duty as realtors to disclose material facts. Before we begin, we're excited about a few new highlights here at Allison James Estates and Homes. The first being our coaching program. This is a program that caters to all levels of production. If you want to be coached by a top producing agent, understand your weaknesses and how to overcome them, and increase your social media and marketing knowledge, this program is for you. Other highlights are Real Estate Tools and Technology Tuesday and Fun Facts Friday, which will feature anything related to the tools AJI offers. Both are live on Facebook. Lastly, please don't hesitate to schedule a one-on-one call with me for all of your questions concerning our systems here at Allison James, or if you just need a refresher course. Please feel free to contact me at support@ajicorporate.com. And without further ado, I will hand the spotlight over to Bob. Welcome, Bob.
Thank you so much. Good morning, I guess afternoon in some parts of the country to all of you who have checked in today for this webinar. By introduction, I am a practicing real estate broker and a real estate attorney. If you folks want to reach out to me at the end of the presentation, I'll give you my email address and you're welcome to send questions or comments. And with that, we'll move into our presentation, which is a failure to disclose material facts and how you can spot those situations that might get you in trouble. Today, we're going to discuss 6 failure to disclose real estate lawsuits where agents were found themselves in the failure to disclose minefield. So we'll move briefly at first to kind of get a little context, and then we'll pick it up a little bit more in detail later on. My hope is that this information today is going to help you recognize situations that could get you in trouble. And so we'll also discuss the duty to disclose and how those duties arise. So with that, let's move to this first case, and I call it the case where it rained twice. The situation that we're dealing with here was a major builder, and this builder had constructed these homes during heavy rainy season in California. Now, the agent who was the in-house agent for the builder, and I won't mention the name, built this $700,000 house, and during the building it rained. Initially, they dried it out, and the agent provided the buyers with a disclosure that it had rained. And the agent specifically made these claims. First of all, not to worry, the house has been dried out. And number 2, it's as good as new. There was a $2.3 million award against the builder, the agent, and the broker for failure to disclose. We'll get into more details about that a little later on. The next case I want to bring to your attention is what we call the dinner theater case. This case involved a theater in Escondido, California, actually. The buyer hired a broker associate with a large nationwide brokerage house. These were the statements made by the broker. I met with the city, and 2, everything is a go. Now, the second comment, everything is a go, might be a statement of fact, or it might be an opinion, and we'll discuss the difference between the two. When you get into statements of fact, there are several problems that can arise. Now, this agent made representations that he had special skills, that he had done this type of work before, and that he would be able to help the buyer through the process. This case resulted in a $350,000 judgment for fraud against the associate broker and the broker house itself. The next case, and there are 6 of these, so be patient as we go through these facts, is the late night basketball case. And what happened here is the listing agent formed this particular area and worked it frequently. No one ever asked if there were kids playing basketball, and no one ever mentioned anything about basketball. One of the interesting facts was there was a basketball hoop in this paved area of the cul-de-sac, which never came down. The hoop was noticed by the buyer, and several of the neighbors had children in competitive basketball, and no one seemed to notice or care anything about the hoop. Well, the house, after this case was over, it was found that there was a failure to disclose this nuisance in the neighborhood. The house sold for $75,000 below market by these buyers who had closed the deal. And the buyer, in addition, received a $425,000 judgment against the agent and the seller for failure to disclose. The next case that we're going to bring up is what's called the nuisance neighbor case. This case is a situation where the agents were kind of crafty in their disclosure. There's an adult son living with his parents next door. In fits of rage at night, this individual would scream and holler and throw things. The sheriffs had been called. When asked about this nuisance neighbor disclaimer, because the seller said to their agent, how should I deal with this? I don't want to slander my neighbors. And the agent came up with this very inventive idea. We'll just call that person a nuisance neighbor and see what happens. That really wasn't a full disclosure by any stretch of the imagination, given the fact that this person was such a problem. But the buyer's agent saw this and said, well, what does this mean? To which the seller's agent responded, oh, he blows leaves into their yard, which was a true statement. So you can see where this is going to go, I'm sure. The next case is the one-way path case. And this involved a house where the seller was aware that one room had a cracked slab. And every time the house was shown, and including to the agent during his visual inspection, the owner led them out the house in a way that the crack would not appear visible. It was about 1/8 of an inch high, and so there was no question that the owner knew, the seller knew the crack was there, because when you vacuum the carpet, you would hit this crack. Now, the agent denied ever seeing the crack, which was not believable, and the result was a fraud judgment against the seller and a negligence judgment against the agent for an insufficient visual inspection and against the broker and the home inspector. The cost to repair the slab, attorney's fees, and more were awarded. It came out to about $325,000, which was more than the cost of the house, actually. Let's move one more. The seller gets full price. This is a situation where the agent's involved in the deal. So what happens is the agent lists the house. The seller says, this is how much I want for the house. And then the agent becomes aware of someone who's really interested in that particular location and that property, and realizes that she can make $110,000 profit on a double escrow by flipping the house. I don't know if any of you have been involved in that, but this happens frequently, I'm sad to say. So what happens is the agent creates a double escrow, pays the seller full price for the house, flips the house, makes $110,000 profit. Judgment, fraud against the agent for concealment, which is an intentional fraud, and against the agent's broker, responsible for the acts of the agent. The profit that the agent made, plus punitive damages, plus attorney's fees, all added up to $680,000 that the brokerage house and the agent had to pay. Let's see the next one. Okay, so those are kind of the cases that illustrate some of the frequent problems that agents find themselves in failure to disclose. And so now I'm going to kind of back away from that and hit a couple of these material facts. So what is a material fact that you have to disclose? And simply put, it's anything that the buyer or the seller would consider in making the decision to go forward. Now, anything seems like a bit of a stretch, but the courts have been pretty clear about this. If the seller or the buyer might have changed their mind because of a fact that they didn't know, you're already in the failure to disclose world, and it's an uphill battle to survive. So we have a duty to disclose, and how do the duties arise? They come about by, well, first of all, let me deal with this slide, which is a definition duty. And I reached down and got into the etymology of duty. And the thing that's important to note is that it's due now. Your duty to disclose is due presently in this moment. And so all of these duties are things you have to comply with now. It's not something you can come back later and fix. If the buyer has moved into escrow, and after they're in escrow, you start disclosing stuff, the buyer can close the escrow and still sue you for fraud. So once the buyer has relied and taking some course of action in reliance on your concealment, you're on the hook. All right. Most of these things, or most of these situations, can be remedied by just simply being honest. Everybody that's a real estate professional owes the public a general duty to be honest. When you start concealing material facts, you're really moving away from your duties as a professional to help close a transaction. Remember, our role is to assist people in making, for the most part, the most important and expensive financial decision of their lives, buying real estate. All right. Some agents seem to think that, well, if I tell my buyer to hire an inspector to check out the county records or to do whatever, that they're off the hook. In other words, you need to go check this stuff out. Well, if that fact that they're asking about is within or should be within the knowledge of a competent agent, then I think you're in trouble. You can't just leave your client hanging loose, so to speak. Let's see if I can move to the next. I'm not quite sure where. Okay, here's another issue that some agents seem to think is going to cover them. And it's where we get to the sold as is, but all material facts still need to be disclosed. So you can say to your potential buyer and your listing, this property is just being sold as is. You take it the way it is. We're not going to fix anything. We're not going to help you with anything. We're not going to address anything. Don't even bother sending the request to repair. You can do that, but still, if you know of a material fact that the buyer doesn't know about, you have the obligation to disclose it. Now, folks, if you want to jump in and ask a question as we're going along, Tracy, you're welcome to interrupt us here at this point, and I'll start taking questions. I don't want to get too far down here.
I'm here, and I'll let you know as soon as any questions come through.
Sounds good. Thank you.
You're welcome.
All right. So now we have this concealment is fraud, and that's something a lot of people don't seem to understand. I've heard agents make comments like, well, if they want to know, they'll ask. Or, nobody really cares about that kind of thing. Or, they have an agent, let their agent ask and figure this stuff out for them. Be careful when you get into that mindset. You should have a red flag waving in front of your face going, I think I better talk about this with somebody. And if you have a question, if you're not very experienced in the industry, it's a great thing to take up with your broker, your supervisor. Hey, this has come up. Is this something we should be discussing? Because remember, the best defense is just to not get involved in a failure to disclose situation. All right. So now, what do we have to disclose, and how do you get in trouble disclosing? There's material facts, which are stated as facts, and then there are opinions. You're not going to be held to your opinion. If your opinion is that, well, I think this is going to be worth more money down the road if you buy it now, when you talk about future events, you're talking about opinions. If you say something like, oh, there's going to be plenty of square footage here for you to put in a pool. Now you've moved into an area where you are expressing a present day fact. So if you're going to get into a situation where you're having a discussion with somebody and they start to ask you questions, it's really important to make sure that you couch your response in an opinion. Something like, well, when they put the new street in connecting the harbor, values will double. Now, that's a statement about a future event, and you're simply expressing an opinion. But when we talk about there's enough square footage to get a pool permitted, you're talking in a present day situation. So you need to have those things clear in your mind. And if you are concerned that you might have wandered off into stating facts, you need to follow up an email to whoever you're talking about saying, you know, I really don't know what's going to happen. Or you can also disclaim, this is what I was told, but I don't know. So you want to stay away from making statements of fact when you can. I think I covered this a little bit, but I'll go over it again here. When you have a situation where a professional holds themselves out as being specifically qualified, and the other person is situated so that they may reasonably rely on that superior knowledge. Now, this is language that comes right out of the cases. And in fact, this is the theater case. You'll remember that this broker associate said, oh, I've done this before. I can help you. I can marshal this stuff through the city. What that person's doing there is stating they're specially qualified, and the buyer in that case reasonably relied because the agent or the broker supplied all kinds of qualifications and what I like to call as bona fides that they were able to do this. When that situation gets set up and a fiduciary is involved, and by the way, an agent is a fiduciary of the principal. So if you're an agent, you're a fiduciary through your broker, and the broker has the agency relationship with the buyer or the seller. But that fiduciary relationship places a heavy burden on you to take care of your principal. So when that person states an opinion as an existing fact, your client doesn't have to do anything else to check out if you're right, wrong, sideways, lying. They can simply rely on you. Now, we have the real estate professional who has superior knowledge about most real estate transactions. So you fall into that category just because you have a license. If you've managed to get the education, pass the test, get a job as a real estate professional, you have superior knowledge. And you're kind of in a position where you're supposed to be helping your client with that superior knowledge. All that means is they're going to rely on what you say, and they have a legal right to do that. So when you're talking about your superior knowledge, oh, I've worked in this neighborhood, I know all about this neighborhood, yes, I can help you with that. You need to be sure that you couch those statements as an opinion if you can. Otherwise, you're turning your opinion into a fact because you have that superior knowledge. You're an expert. All right, where are we here now? One of the ways you can avoid being caught in a failure to disclose when you're making comments, let's put it that way, is to identify the source of your opinion. If you're not the source of the fact, you're going to be in better shape. An example would be, well, the seller stated that there was sufficient footage to put a pool in here. Now, the source of that fact is no longer you, and you're just giving an opinion. Some agents seem to feel like it's necessary to be very knowledgeable and very informed, and that gives them a lot of bona fides again, or standing with the client. I don't do that. All the years that I've done this, if I don't know, I am quick to declare my ignorance, and I recommend you do that too. There's nothing wrong with saying, you know, I really don't know. Be careful here, because you don't want to follow that I really don't know up with, oh, I'll go down to the zoning office and check for you. Because if you make that statement, now you've assumed that duty to go find out something. And you get into other problems there, which we'll get to a little later. State it as an opinion. There's nothing wrong with saying, this is just my opinion, okay? And then, like I said earlier, if you're doing that, document the conversation. Do an email, send an email out to your client, whoever you talk to, and say, well, you know, we discussed this yesterday, and I just want you to know I'm not an expert in zoning, but the owner did say that there was enough room. You might want to check that out. All right, let's see. Where are we now? Oh, yeah, this is another thing. I've dealt with agents both as a broker and also as a real estate attorney in litigation where the principal's discouraged. There's nothing to worry about. there's not going to be any problem getting that approved. And we go back to the theater case now. And in the theater case, the broker was queried by the buyer. Now, and the buyer said, I don't want to close this escrow unless I can convert this theater. So I need to be sure this is going to work. And the broker said, made the statements, I've checked with the county, I've checked with the building department, and there's nothing to worry about. It's a go. Now, the it's a go was a critical fact in the case where the brokerage house wound up paying the buyer a lot of money. And the reason was that it was not a go. And we knew it was not a go because the infrastructure, the sewage and the water, wasn't sufficient to convert this old theater into a restaurant. And everybody in the city knew that. And they were unable, the brokerage house was unable to find any witness in the city who said they discussed the matter or that they would have, under any conditions, told the agent that, oh yeah, there's no problem. So don't worry about it is a very dangerous thing to be saying to your principal, because in a real estate transaction, frankly, in my opinion, you should worry about everything. So how specific does your disclosure have to be? At a minimum, it has to be sufficient to alert your principal or who you're dealing with to make an inquiry. In other words, you have to tell them enough so that they're asking questions. I guess the simplest way to put this is just tell everything. If you've held something back and later on that comes out that you held something back, it's almost impossible to recover from that, because once you have been kind of sneaky or deceitful, nobody will believe that you weren't that way in the entire transaction. Now, how often do you have to disclose? This gets us back to the it rained twice case. The first disclosure was, hey, it rained, the house got wet, and what we're going to do now is we've had all the drywall that got wet replaced, the house is dried out, and it's good to go. After that disclosure was made, and it was made in writing, there was a second rain. And the second rain soaked the house again. Well, the builder went in, dried the house out, at least they said they did, and replaced what was damaged. Well, as it turned out, the house was still wet. The second floor was not dried out. The buyers asked, is the house okay? And the in-house agent for the builder said, oh yeah, everything is as good as new. Well, as good as new turned out to be the statement that hung them. Because what happened was, as the house really dried, it warped, twisted, changed. Walls weren't level. And that's not the worst of it. As the builder came in under the warranty provisions and started trying to repair these problems, they did a terrible job isolating the work areas. And so there was a lot of contaminant that was in the living area with the family. And because the upper floors weren't completely dried, mold established itself. The small children got very, very ill. The little girl almost died. And of course, you can see where that's going to go. That second disclosure was required, and it was required to be in writing. There was a finding of fact and a legal conclusion by the court before it ever got to the jury that there had been an inadequate disclosure because it hadn't been in writing. So when you learn things after you've made your disclosure or after you've done your agent's inspection, it's really important for you to disclose again. You cannot get in trouble by over-disclosing. Some agents worry, well, man, if I say that, I'm going to lose, escrow is going to fall out, and the buyer's going to walk, and I don't want to do that. If you're in that headspace, if that's how you're thinking, you're already in the disclosure minefield, and you're probably already going to be in a lot of trouble. Let me see if we can move to the next slide.
We do have a question, Bob. I've been.
Oh, go for it.
Yeah. Okay. So we have, it's actually our broker in Tennessee, Patricia Corcoran, saying, if your parents are selling their home on their own and you know of several hidden problems, wiring, etc., do you have any obligation to say something to the realtor buying it?
Okay. The you, I assume, is the broker or the agent. If you are not in a agency relationship, you're not involved and you don't have any duties. However, the seller has an obligation to disclose all known material facts about the property. So if you have a wiring problem or any kind of problem with the property that might cause the buyer to change their mind, that's a material fact, and that has to be disclosed. Now, I understood the question that it was apparent. And so I don't know that there's an agency relationship there, but let's take a situation where you are the agent for the seller and you become aware of a problem with the property. And the seller says to you, yeah, but I don't want to talk about that. That's an issue. It's kind of like the crazy person next door case, the nuisance neighbor, where the seller goes, I've got a kind of problem here. I'm not too sure I want to get into this. And the agent then helps out, where the agent then says, well, let's try to just list it as a nuisance neighbor. Or maybe we can do on the electrical thing, we can say, we thought there might be some problems, or there were in the past. Those hedged statements are dangerous. The disclosure has to be sufficient to put the buyer on notice to make an inquiry or an inspection. Flat out concealment of the electrical problems is fraud. It's fraud by concealment. So the answer to your question is it should be disclosed. And if it's your parents, you should definitely make sure they disclose it, because you may lose your inheritance in the lawsuit.
Yeah.
Okay. Are there any other questions?
There are. Assume. Are you there?
Oh, yes.
Okay. So Gwen Bachman says, assume seller's property has had a full home inspection on his 100-year-old home. He needed to have the basement beams reinforced. Seller had a structural engineer come in and evaluate. Correction was made. Would you suggest that the details of the repair be added to the disclosure form?
Okay, the short answer to that question is yes, because disclose, disclose, disclose. So if I understand the situation, what has happened is the seller has become concerned about the structural integrity of the building, and the seller has had an engineer do a survey and make some recommendations and repairs made. I don't know what state we're dealing in, but in California, in the disclosures, you're asked, has there been major repairs done to a component of the property? And if so, what? And so you're queried in your disclosure forms to disclose that very event. Apart from that, if it's not a part of your disclosure forms, whatever state you're working in, you have the obligation to tell the buyer about that, because it involves a major structural component of the property. And so if I understand the other, maybe this is the question, has that relieved you of your obligations to disclose? Here's where we get into, you must disclose what you know, but you don't have to disclose what you don't know. And so if you don't know there are problems with the building, let's do it this way. Let's say the seller never hired anyone to do a survey or to determine if the structure was sound, and didn't have a reason to believe that. In other words, they didn't see a cracked beam or the floor hadn't given way. They don't have a reason to believe there's any structural problem. The seller may go, you know, they really built them good back there in 100 years ago. This thing will last another 100 years. If that's a true belief, then there's nothing to disclose. There's nothing known to the seller that is a material fact. However, the way you get out of trouble in this situation is you simply say to the buyer, this is a really, really old house. You should satisfy yourself that this house doesn't have problems. Now, that's okay as long as the seller doesn't know that there are problems and fails to disclose. I hope that answered that question. I kind of rambled on a little bit there.
Well, we do have another question too coming in from
Sure.
Fagda Garcia. She says, if escrow falls for not agreeing to the, I'm going to kind of add my own words here, for not agreeing to the request for repairs, and I start a new transaction, do I have to show the previous home inspection?
Do you have to? I don't know that you have to show the inspection. unless it's requested. Now, in some states, there's an actual affirmative duty in the purchase agreement to provide copies of all inspections and reports. I know that's in California. So if you have that as a contractual obligation, you certainly have to provide that. The only time you would not have to provide that inspection report, if it's in the purchase agreement, would be if it's way long time ago. I know that didn't sound too legal, but it has to be an old inspection report that happened 10 years ago, and it's just not relevant today. But you do have to disclose anything that's on that report, which would constitute a material fact. And a material fact, again, is something that might cause the buyer to change their mind. So what happens is you don't reveal something like persistent plumbing problems, whatever that means. You know, toilet continues to plug up. There's a plumbing problem. You don't disclose that. And later, the deal closes and you have a really picky buyer who has a sister that's an attorney. And now what's happened is they come back and they say, you know what, if I had known that, I would never have bought this house. And it's almost impossible to refute that, because a material fact is something that may cause a party to change their mind. I hope I answered that question.
I think it sounds like you did. And also, I have a question. What about
Sure.
texts? Are texts, will they stand up as your conversation log?
Oh, so that's an evidence question. Sure.
Correct.
Sure. What you need to do is simply document the disclosure. I mean, if you can document it orally, you're in good shape. In other words, there's somebody standing there that heard you say, hey, this thing had plumbing. You know, we have problems with the upstairs toilet. It plugs occasionally. That is going to be sufficient. It becomes a question of fact. Did you disclose or not? A text is an excellent way to show that you disclose because it's in writing. All right, so there you are, Tracy. I hope that answered your question.
It did. Thank you.
So I assume there are more questions. I've moved to the next slide, which is, what does the listing agent have to tell the buyer? And remember now, we have an agency relationship with our seller, if we're the listing agent, but we have no agency relationship with the buyer. But we still have that duty to be truthful. We owe that duty to everybody in the transaction. The days of seller beware, you better check for yourself, you're on your own, dude, those days are gone. We don't do business like that anymore. And apart from the fact that it's unethical, it's also illegal in most states. So we have the affirmative duty to be honest. Now, that doesn't mean we have to go help somebody who is not our agent, or not our principal, excuse me. So this is a quote from a case that is used in almost all continuing education. And it is this, and I'll read it. A listing agent for the seller who knows material facts about the property, and those facts are known and accessible only to him. And the seller who knows the facts are not known or within the reach of the diligent attention of the observation of the buyer. The broker agent is under duty to disclose those facts. Let me use the little example I used earlier. The toilet upstairs flushes slow and it has a problem. Well, that information is really not accessible to the buyer or within the reach of the attention of a diligent observation of the buyer. So you say, well, he hired a property inspector. Wouldn't that put it within his reach or her reach? Well, if the time that the property inspector flushed the toilet, it was slow to flush, yes. But if it flushed okay, the answer is no. So when you're dealing with that other agent or that other party as a listing agent, you still owe a duty to disclose material facts unless it's obvious to the buyer. What would be obvious? There's a retaining wall running alongside the driveway and it's got big cracks in it. Well, if you walk the property, you can see the cracks. So if you didn't disclose those cracks in the retaining wall, can the buyer later come back and say, aha, here's the disclosure form, there's nothing about a retaining wall? You're off the hook. And you're off the hook because it's readily available. The attention, if you're paying any attention at all, you'll see the cracks in the retaining wall. All right, so let's move to the next one. What does the listing agent, let's do it again. What you don't have to disclose as the listing agent. You don't have to tell the buyer or the buyer's agent, hey, this would be helpful. Why don't you go down to the county and check the zoning? Or, you know what, if you don't hire a building inspector, you might wind up being sorry about that later. You're not in a position where you have to advise the other side. Now, of course, this doesn't apply to situations where you have dual agency. Let's see if we get there. All right. This kind of gets us back to that case where we had the undisclosed profit, $110,000 that the agent made in the double escrow. The reason that's not okay to do is because as the agent, everything that you're doing, every opportunity, every advantage belongs to your principal. You're there to protect your principal. You're acting in a fiduciary capacity, which means that you basically have to throw yourself under the bus to save your client. So if you're worrying about your commission or you're worrying about how much money you're going to make in the deal, your focus is not as a fiduciary, because a fiduciary cannot consider those types of things. They have to take care of their principal, and in this case, the seller. So the listing agent in that case, I mean, the seller got 100%. Everything the seller wanted, the seller got in that deal. And the listing agent was beside herself. Like, why can you possibly complain? How can the court possibly give you the benefit of this deal when you got everything you wanted? It's because the seller didn't get all the benefit available. The agent knew that there was somebody that would pay $110,000 more for that property. That was an opportunity and an advantage that belonged to her principal. So that failure to disclose that material fact is a breach of fiduciary duty. And that's important because once you get into fraud or breach of fiduciary duty, you move over into what's called punitive damages or exemplary damages, damages to punish and to make an example. And that becomes really difficult to deal with. I guarantee you're not insured for that. Your insurance company will not pay for punitive damages. And in a lot of the cases that we discussed earlier, there were punitive damages, and the punitive damages were quite significant. So you need to be particularly careful of this kind of a situation where you breach your fiduciary duty. All right. Well, okay. The subsequent disclosure may not save you. And we're back to that soaked house. You know, the buyer, once they ink that deal, has choices. They can cancel the deal. They can close the deal and sue you for their loss caused by the undisclosed material fact. So even after after the escrow is established, once that deal is inked, you really can't save yourself. And so if you find yourself in a situation like that, I recommend groveling, pleading, begging, paying money, doing whatever you need to do to make that buyer or that seller happy so that they will not come after you after the fact. And get that agreement, a waiver from them. I understand now that the toilet upstairs flushes slow and I still want to buy the house. You know, I relieve you of the obligation to disclose this. You need to talk to your in-house counsel about how to structure that. Hey, I think we reached the end of the presentation. I hope I didn't go too fast for you folks, but I'll be glad to back up and answer any questions that you might have.
I think you did great. Why don't you tell people again your email where they can find you or
sure.
get a hold of you?
Absolutely. We're located in Southern California, San Diego County, Carlsbad. Our real estate brokerage house, which does principally property management. You can reach me at that location by emailing Bob at ambassadorpm for property management.com. And if you look at the bottom of the screen, you see ambassador there, and it's the PM is for property management. So it's ambassadorpm.com. I'm also a real estate broker expert witness, and we do litigation in California. If you want to reach me at that location, my email address is bob at, and there are 3 letters, BLG, that's for Business Law Group, okay, .legal. So it's Bob at blg.legal, Legal. There's no com or anything. That's the entire address. And I hope this was beneficial to you folks.
It is actually, Bob, we actually had a couple come in, a couple questions since
Sure.
you were telling us about you. How long after the deal closes does the buyer have to come after the seller?
I understand the question. The question is, what's the statute of limitations?
Correct.
And the statute of limitations is different in every state, usually. In California, the statute of limitations for fraud is 3 years after the fraud occurred or the defrauded person reasonably should have learned about the fraud. And you have a 4-year statute for breach of contract. So even though you might escape the fraud cause of action, you'll still be on the hook for 4 years on a breach of contract cause of action, and that would relate to your listing agreement with the seller. Let me see if there's another one. Negligence.
What about, is that something that would be different by state, so they should just ask their broker?
Absolutely, because the state, it varies state to state. Statutes of limitation are a creature of state law, not federal law. There are some federal statutes, but I don't think they'd be involved here. So you also have the breach of fiduciary duty. In California, that's a 3-year statute. So you're looking at a minimum of 2 years, which is for negligence in California, 3 years for fraud and breach of fiduciary duty, and 4 years for breach of contract. So I hope that answered that question.
Yeah, and there's another one that came in from Vivian Arias asking, you mean after the disclosures are provided and signed, all the facts aren't known until those disclosures are provided? So I would think that would be yes, correct?
I didn't fully understand the question.
Okay. Let's say it again. You mean after the disclosures are provided and signed, which would say yeah. Well, I'm not an attorney, so I'm going to let you.
Let me jump into that and see if I've heard the question. So the disclosure forms have been signed and provided, and so we're in the escrow period where disclosures have been made. And correct. So we've disclosed everything except the slow flushing toilet or the nuisance neighbor or the basketball game. That hasn't been disclosed. And so that's where we are now. So the question is what?
I think you pretty much just asked.
Okay. You're still
rhetorically answered that. So yeah, because she's saying, you mean after the disclosures are provided and signed, all the facts aren't known until those disclosures are provided. But technically, not all facts. If you are not disclosing material facts, then you're not disclosing them, right?
Yeah. The question is, the question really is are all the material facts disclosed?
And that was the answer.
If the form is signed and sent forward and there's a material fact that's not disclosed, you're still on the hook for that material fact not being disclosed. Exactly. You might remember that, and you need to be aware that you as an agent might be responsible for discovering material facts. So remember the house where the seller led the people through it a particular way. And it's interesting because I went through that house several times. I was involved in the litigation. And as you go through the way the seller would lead people through, there was bright light out in the yard through a sliding glass door, and you just didn't notice that the floor wasn't level unless you happened to actually step on the crack. And so you have a duty, at least in most states, as an agent to do a visual inspection because you are specially qualified, because you're licensed. And so whatever's you see as an agent that would put you on notice there may be a problem in your visual inspection, you're required to disclose. So you need to be very careful of sellers who like to help you inspect the house. Mm-hmm. Oh, here, let me show you this, let me show you that, because they're probably leading you away from something and calling your attention to things they know are okay. My recommendation to agents and brokers is if when you do your visual inspection, you just have the seller go away and play with the kids or water the garden or something, and you sit there in the quiet moment and look and think, if I was buying this house for my kids, what would bother me here? And you will generally find what's visually that you should notice visually to disclose. There you go. Any more questions?
Yes, there are. Actually, there's 2 more. So
Sure.
we have Melissa McCune, my friend here in San Diego, is asking, well, first a statement, closed a buyer side in February of 2017. Property had evidence of rain runoff. We asked the seller about it. He said they had no further rain. Oh, no, they had no further runoff. It was of the mudslide. Now, just recently, next door neighbor shows pictures of major mudslide, January of 2016. The seller had to actually move the mud with a backhoe. Should they have told us about the 2016 major mudslide?
Okay, interesting question. And interesting for this reason. They did disclose that there were mudslides. Okay, and if I understand what the question, how the question was posed, it was they didn't disclose a subsequent mudslide that occurred. Now,
Well, she is saying, Bob, that I did note the evidence of the rain of the runoff in my
okay,
Avid. Again, seller spoke directly to the buyer and myself when we went to the house.
okay. So it sounds like, with the little information I have, that the runoff was obvious, and so the agent could detect that in the visual inspection.
Okay.
And the seller said, we have a runoff problem here. Now, if the question gets expanded a little bit, it would be this: well, is there an existing problem or not? I think in that situation, the buyer is on notice that there's a problem with the property and the runoff has been disclosed. And so now the buyer can't just simply sit back and do like the three monkeys: see no evil, hear no evil, speak no evil. The buyer now has to protect the buyer.
Correct.
Even though something hasn't been fully disclosed, when you're put on notice, sufficient notice, that this may be a problem, the buyer then has the duty to himself or herself to act diligently and to inspect and determine if this is going to be a problem. Now, moving forward, in this fact pattern, it looks like the buyer had to incur cost and removing mud, and there's a possibility that if the disclosures weren't sufficient, and I don't know the full disclosure, they may have a claim for damages because they incurred those costs. But it seems to me, on the basic facts that I've been provided, that the buyer was put on notice. There's a problem here, and it was disclosed that there was runoff. So I don't think that, when you're standing there inspecting the property and you're looking at it, there's nothing that's concealed. You see the slope, you see the bank, you've been told there's runoff, you can look at it. I think at that point the agent's probably done enough.
Okay, then we do have another from Lillian Marquez Baraniek. Sorry if I killed your name, Lillian, out there. What happens if buyers have not become aware of a number of years after purchase? Does 3 years begin for fraud then? Is there a certain number of years? But again, I think that would be, we want to make sure some of these legal
Yes,
issues are directly taken to your broker. So
I'm going to do the disclaimer here.
thank you.
This is not the situation where you can rely on what I'm telling you as legal advice. So pay attention to that disclaimer, because I would need to know a lot more facts before I could give you a legal opinion. So we're just talking about my general understanding of what you're asking. And so here's what I got. When does the statute start to run? And it differs in different states. On a breach of contract, it occurs when the breach occurred. On a fraud issue or a tort issue, it occurs when you discover or reasonably should have discovered the fraud or the misrepresentation. So let's say we have the earlier question about the old house with the beams, and the seller had made some repairs to the beam where it was really faulty and didn't disclose that. So, but he concealed it very well. Oh, this comes up frequently in mold cases, where the seller gets a bucket of Clorox and washes the mold area under the sink and then paints it. Mm-hmm. And so people buy the house, they're happy, everything's good, and then a year down the road, something starts to happen. There's a leak in the sink, moisture intrusion appears, and then mold starts to grow again. So in that situation, it would be when they discovered that the concealment had occurred. And so I guess the answer to the question, the way it was phrased, is if the buyer discovers the fraud and there's no reasonable way they could have discovered it before, at the point of discovery is when typically the statute starts to run. So without a lot more facts, I guess the real query is, hey, how long am I on the hook? And you're on the hook for quite a while. 3 years may not save you. The statute might be told, especially if it was a concealment issue. So I hope that answered the question.
Okay, I do have people asking me too where they might be seeing our webinar, and you will find that at AJI University. It will be put there within the next day or two. So if you do want to come back and attend again or watch again, that is where you can find it, or you can always contact me here at support@ajicorporate.com, and I will lead you in the right direction also. So with that being said, Bob, I want to thank you very much for, again, this was riveting. And I think that no matter what state it is, being that Allison James is in 16 states, we all know when there's not a material fact being disclosed, and just tell the truth.
Well, I appreciate the honor of being able to present to your agents and brokers, and I hope this certainly helps somebody. It wasn't meant to be a lesson in law, but it was meant to kind of give you situations that might occur, so that red flag goes off and you can back up and go talk with your broker or go review what you've done and be sure that you're safe, because it's a terrible thing. I can't tell you how many agents or brokers I've dealt with when they go, surely I'm not responsible for this. I mean, I did everything I could do, and it's sometimes very distressing to tell them that no, actually you didn't do everything you could do and should do. So again, I hope this helps you stay out of trouble. And with that, God bless you, and I appreciate the opportunity to speak with all of you.
Thank you very much again, Bob. If you do have any questions, please feel free to reach me like I have told you. Please set up a one-on-one call with me. I'd love to go over anything on Allison James University with you. Tune in on Tuesdays and Fridays on your Facebook pages for our Real Estate Tuesdays and Technology and our Fun Fact Fridays. And until next month, everybody, have a great Thanksgiving. Bye, everybody.
Okay. Are we gone? We are. Are you still there, Tracy?
Yes, I am.